mean, her point that it is quite vague and subject to police interpretation at the time means that law means whatever somebody wants it to think to be at the time. I think she did make a mistake. I think to cite a case that was obviously an aberration and got turned over, that was a mistake. Because, I mean, the court made a mistake, police made a mistake, at least it got fixed. What is a little bit more concerning is one of the cases where defending their own home against a home invader, and they were charged, and that, you say is obviously wrong, and the court made a mistake. What is perhaps more the question is, how would you improve the law to achieve the same purpose more clearly and better?
Yeah, I think that is the question actually. Yeah, and that's the question I would like us to tackle actually, as a community and as a project in response to this. Just a counter argument though that you're saying that citing that example was potentially a mistake of hers. I think what she's demonstrated there is that by applying the law, there is so much room for interpretation such that this extreme example, while it might be considered an aberration, not an everyday occurrence, it was possible within the legislation, and it got so far through all of these supposed checks and balances, it got so far through the court system that the only way to undo it was to go to the Supreme Court. I've got this idea that having to defend oneself is a punishment in itself. So by mere accusation, you can be punished. And you can be punished just by having to actually answer to accusations which are false or it's sort of, people can even use the law maliciously in this way to exact vengeance or harm on other people.
That's right, and I'm not sure what the word would be for something that is one step more than investigation. But if somebody were so thoroughly investigated, that is tantamount to a kind of punishment in itself. I mean, if you knock over a home invader and they're wounded badly, but it is because they've been dangerous to you, obviously they need to check that you weren't just trying to knock somebody off. But I think the kind of investigation or the way it's done doesn't need to be a punishment in itself.
Yeah, I totally agree. I think we can have a legal system where it is not a punishment to be investigated, and it's not a punishment to collect facts, and only when there is an overwhelming amount of fact does the legal system actually engage to prosecute. At the moment, though, there's no pre-existing burden of proof required. There's only a thing called prima facie evidence. So if there's enough evidence to point to a law being applicable, then a charge can be brought forward, and then the police can actually investigate further and bring a whole heap of evidence to bear. And that's the legal system within Australia.
Prima facie basically means on first appearance.
Exactly,
No more than that.
Yeah, exactly right. So we do have a system in Australia that can be abused by the authorities, not necessarily maliciously, not necessarily by intent, but the public is a victim nonetheless.
Well, let's look at this from an equivocation point of view. What's more likely to be abused? The due process of the law, in the sense of somebody being charged with something and it being taken to the whether or not there's enough evidence to have the case heard properly, whether it's just going to get thrown out. That's one question. The other question is, or the other scenario, and I want people to try and weigh up between these scenarios, is it more likely that that will happen, that someone will be unfairly charged and dragged through the courts, or is it more likely that someone will be beaten up by the police for being a dick because the police don't have enough to charge them with, right? And I would argue that the risk of police brutality is far higher than the risk of abusive legal process.
Interesting, yeah.
Maybe not in Australia, but certainly in the US.
Yeah, I see your point. Yeah, so everybody involved in the case knows this person is guilty. They don't have the evidence for it yet. They can't get any traction on the case, and so their solution to that is to take it into their own hands and beat upon this person that they believe is guilty. Yeah, I see your point.
And sometimes the police beat people up just because they annoyed them, and it's that sort of thing that says that maybe the problem isn't with the courts, maybe the problem is with the police force, but I don't know enough about either to point the finger at. I just want to remove the initial assumption that the biggest problem might be with the courts or with the legislation. Because personally I see that the law as it stands exists to prohibit vigilante activity, where vigilante activity could be defined as people deciding to beat up somebody because there's a mob and they see someone committing a crime and then they pile onto that person. Whether it was a violent crime or not, the risk is still there. And so the law exists to stop, to try and defer, detract, what's the word I'm looking for? Deter. I think deter is the right one. It's there to deter people from committing crimes in the first place, right? You know, either opportunistic crimes or planned crimes. And it's also there to stop people committing crimes in the process of trying to do what effectively should be the job of the police, previous statements notwithstanding, and to prevent vigilante activity. So the question could be raised, and I'm not exactly sure the presenter raised it in a Socratic sense. I think she predetermined the outcome. The question could be raised is the use of lethal or potentially lethal force ethically justifiable in the case of a home invasion? And I would say it depends. And it depends is a really wishy-washy statement to make, but the bits of legislation that the presenter put up on the screen actually seem to have been written in a fairly straightforward way that takes away the indefinable "it depends" statement and replaces it with things like proportional use of force and carrying of something with the intent to use it as a weapon, or having modified something into being a weapon when it wasn't previously. So that the law seems to state out specific things that can be shown to have someone be outside the realms of self-defense and going into the realms of vigilante activity. Or, you know, somebody like attacking someone with a weapon when that person they're attacking by the claim of self-defense doesn't actually have a weapon at all. So, you know, I think that's why the law's there. And just because something...
So let's flag the moral issue, because that's something I think that we need to talk about.
Mm-hmm.
Yeah.
I think an issue also is that it's different laws in different places, different interpretations in each different state and country. Stop or I'll shoot. Told you that's what I'd do.
We'll see.
Stop, I'm
I
shot.
think in
That's
the
okay.
US it's still a law that if you're in your house, you are allowed to defend your house. In Australia, you don't automatically have that complete right.
Well, you do, unless you use disproportional force.
Which is
Yeah,
Pretty
so if
much
somebody
measure.
comes in with a gun, you're able to come back with a gun.
Mhm.
Yeah, if someone comes in with a baseball bat, you're able to come in with a slightly bigger baseball bat. But if somebody comes in with, butter knife, and you bring out your bazooka, disproportionate force.
That's right.
Someone's got a hidden weapon, so you don't pick anything up on the way to defend yourself.
Yeah. I think one of the reasons why people are so sort of disheartened by this law and by some of the outcomes of when this law gets exercised is that the law doesn't seem to acknowledge the chronology of wrongdoing. So, disproportional force, well, I would never have been in a position of needing to put forward any force whatsoever if this other person hadn't done the wrong thing that they had done, enter my house with the intent of stealing my candlestick holders.
But in the same vein, just because someone's a criminal doesn't mean that they should waive their rights to bodily safety, because we don't have corporal punishment or capital punishment in this country anymore. So just because someone's committed a crime, why does that necessarily mean that they waive all right to safety? I think that's part of what the law's trying to do, is it's trying to say, even though someone's obviously guilty of something, doesn't mean that they've waived all of their human rights.
I would agree with that to an extent though. You've got, every person has the ability to take on risky behaviours.
Yeah?
Everybody's got the ability to do that. So, I can go on a holiday to Bali, I can get into the dodgy parachute, it's got holes in it, tears in the, the harness and all that sort of thing. I can do that knowingly, consciously, do it for fun. It snaps, it breaks, I fall to my death. That's, yes, that's partly on the operators of the ride, but the point is, you've knowingly done that. You've seen standards of safety, and you've seen places where safety doesn't exist, and you still make the choice to go ahead, right? So in this case, it's reasonable to expect that if you're entering people's houses to steal their stuff, for example, you're entering a space, you're performing an activity where there is a good chance that somebody will want to defend themselves. And
Yeah, of course.
Yeah, so you've
taken... Nowhere in the law does it say that if someone comes into your house, that you aren't allowed to restrain them. It doesn't say that you aren't allowed to perform a citizen's arrest. It doesn't even say that you're not allowed to yell at them loudly. The law exists to prevent you from seriously injuring or killing the person who's come into the house. That's what I would argue.
But see, in WA you have a law giving you citizens' arrest rights. And there have been successful citizens' arrests, and the police can only say thank you very much, you did the right thing. But they don't recommend that you do it because the chances of getting arrested for assault yourself are very high, even though it's completely legal. And defending yourself, the chances of you being prosecuted for some heinous act are very high, even when you're not doing something illegal.
Yeah.
I kind of look at the law, and this is almost a perfect example. You have right over here and wrong over there, and it's a very fine wiggly line between the two, and sometimes it's a bit fuzzy and it's hard to figure out exactly where to put it, and everybody goes through with all their legal language trying to make the line clearer and harder, and even though it's very wiggly, because some things that look like they're wrong actually are right, and vice versa. It would be good if they could firm up this kind of legal stuff, so that it wasn't vague, and so if you did some harm to a home invader, you weren't going to be arrested or sued or anything like that.
Yeah. I think one of the main points she's coming to is that there is no protection for those who have justifiably defended themselves
Yep.
and then found themselves at the mercy of the courts, defending themselves legally. So,
And on that point,
yeah.
she's dead right.
Yeah,
Yeah.
absolutely.
I think she's dead wrong.
Really?
I think that there's three levels. First is the police, second is the law, as in the letter of the law, and third is the prosecuting or the magistrate or judge or jury that hears the case, right? For someone to be convicted of, injuring or murdering somebody when they were acting in self-defence, they've got to go through all of those three levels and then be found guilty.
Yeah, but at each of those levels, they're going to be applying this incomplete legislation.
What's to say it's incomplete though? How could it be more complete?
I think that's the perfect question. I see this as a perfect opportunity for group discussion and group debate and community-based refinement of the legislation, because I can see a number of different extra criteria being added to this, one being chronology, so that the courts are required to consider chronology of wrongdoing in the protection of the person who's defending themselves. And I'm not necessarily advocating that we just, okay, so wrongdoing happened there, then they took the bazooka and blew their head off, therefore they're completely innocent. No.
Hold on a second. I'm seeing 2 points arise from your point that you're making there. One of them is the one about chronology.
Yep.
And I think that is so hazy as to only be a matter of interpretation by the court itself.
Really?
As in, the court, I think, is in the best position to go, this person was clearly a home invader. We are clearly required to look at the situation for what it is, right?
Yeah.
I don't think the courts will look at a situation where person A injures person B in the same light if it's person A defending their home from person B as they would be person A and person B walking down the street next, towards each other.
Yeah, but keep in mind, they're already in the court to decide the person's fate, this person who has defended themselves, and an outcome has come from their defending themselves.
But isn't that what the courts are for, to make sure that people get a fair hearing?
Yeah, but I think the presenter's point would be that fairness isn't there. There's not a balance on the protection of the person defending themselves.
And where's your evidence for that lack of balance?
There's a couple of things going on here. One is the fuzziness in the law itself, and if you could get the legislation much better, we'd probably have fewer problems like this. Another one is...
Well, hang on a second, would you mind going more into the fuzziness for a sec?
Well, how reasonable is reasonable force? What defines reasonable force?
It's referred to as proportionality, as in you can't use a level of force much greater than what someone brought to bear against you. And it's that Cameron spelled it out, so that the definition of proportional force is really solid. That's not
if you've got a baseball bat and that's all you've got, and you don't have the ability to go get another butter knife to match the butter knife that you've brought in, right? I don't have that ability. I don't have that choice. In that moment, you've invaded my house. I've got whatever I've got.
Yeah, but how likely are you to kill someone with a baseball bat?
That's beside the point.
I don't think it is, because it's not just the weapon that you're using, it's the level of force that you use it with, and that's why it talks about proportional force, not matching of weapons. Well, but it's not vague. It spells out a reasonable enough...
No. The chances are, even if you're completely justified and you seriously hurt somebody, you're going to get arrested, whether it's wrong or right. That's by the by. As I've heard the legal people explain it, the law in WA is actually like you say, it's actually pretty clear, but it's not clear enough to prevent somebody getting arrested when they shouldn't be arrested. Like, you have a right to do a citizen's arrest. The chances are you might get arrested for assault yourself.
Yeah.
But a citizen's arrest is supposed to be putting your hand on somebody and telling them you're arresting them. Citizen's arrest doesn't mean you tackle someone to the ground or start beating them.
I think in WA, a citizen's arrest law, you do have the right to restrain people.
Yeah, but restraint and assault are different things. Deprivation of liberty comes into it if you're restraining somebody without hurting them.
Is there perhaps the ideal of protection being sort of leveraged here? So in an ideal world, we'd all be civil to each other and there would be no circumstances under which any of us would feel any kind of motivation to hurt, injure, harm, kill another.
Can I backtrack a bit? One is what the actual letter of the law says.
Yeah.
The other thing is that in a common law country like Australia, you have a set of court precedents which are binding on a magistrate that's hearing the case. So if it has been decided that this is illegal in a court somewhere else, it could be binding on this particular court, in which case the judge doesn't have any choice.
Okay. So precedent, yeah, so if there's, pre-existing, example. Yeah, I gotcha.
And what happens is you build up this big body of case law, and it restricts what the judge or the magistrate can actually do.
Yeah.
The other thing is two other things. Most people hear about the headlines of 2 lines, and they don't know exactly all the stuff that went on and was discussed in court. So it's easy to draw conclusions from the details without knowing the details of the facts. And there was something else, I can't remember what it was.
Just on the concept of precedent, I tend to think of the concept of precedent as a lazy person's way of creating legislation. In other words, the people that created our legal system, they very wisely understood that they couldn't write into the code of law every possible scenario that would ever exist between now and future time, right? So I get the wisdom of that, but over time you should be able to deduce basic principles that can be upheld under certain circumstances, right? And I don't know that we've got a process in Australia or even in other countries. There's no real process to review the bulk of precedent and to then turn that into overarching principles that guide social outcomes we want.
Well, I would say that there is, and I'd like to jump in here and say that there's two branches of the legal system that create what's known as the law. One of them is the political or legislative branch, because that actually writes the legislation, and that's the politicians doing that with the assistance of the various government departments that advise them. And the other aspect is the judicial branch, which is the courts themselves that make judgments and set the case law, right? There, I would say you're correct in the one hand, which is that there's no way to broadly review the collection of case law in a given scenario. But what there is there's a way to review and revise legislation, and that's the political electoral process.
I do agree, but...
And that's how. Can I give an example?
Yes.
Yeah. The example that I would say is that under a former WA Labor government, possession of a small amount of marijuana for personal use was decriminalised. Doesn't mean it was made completely legal, but what it means is possession of that small amount was taken off of the Crimes Act and put into a different act, so that if you were caught with possession, you were charged with effectively a misdemeanour offence rather than a criminal offence, and your sentence, such as it was you were sent for some counselling, right? and it was no longer considered to be a serious offence on your record, right? And then, as part of the political process, WA kind of bounced back a bit from that Labor government and got a Liberal government that was quite traditional in its outlook, and they reverted that law and made any amount of marijuana possession a criminal offence again, right? And so there's back and forth in the electoral process where people elect politicians and then people and lobby groups influence politicians and politicians make laws. And there's also the committee process within the legislative
There's
framework.
another really good example of that. Residential Tenancies Act during real estate. When you get rat-bag tenants and rat-bag landlords, and the law drifts from one to the other, and back again over the decades. Sometimes it favours the tenants really heavily. They're hard to kick out, and if they wreck your place, what are you going to do about it? In other places, it favours the other side.
Yeah, I think, I completely agree with you. There are processes there. So it's perhaps wrong to say that there aren't processes. I think it would be more to my point that the processes that do exist are sort of, they're influenced by all those things we were talking about earlier about political biases, about reactions to headlines, reactions to an extreme event. So something happens that gets a lot of media attention. All of a sudden, the politicians at the time think that they have to do something about it, and in sort of a knee-jerk reaction, they completely amend the law and they change the law. And then oftentimes, the laws they are changing, don't necessarily need to be changed because they've actually been applied well, and we've got an outcome that is consistent with what should happen. Yet they've been in the media and felt like they've needed to change the law for whatever reason.
But the judicial branch can invoke some amount of sway against laws that are considered unjust.
That's
true. It's sort of, so I guess what you're saying is,
and
what we're alluding to is
shown
that
to be
there's
illegal.
scope creep. There's sort of scope creep within the legislation, and there's back and forthing, and it can be affected by political bias and stuff like that.
One of the things that I think you're kind of getting at, but it didn't come across as much because we went into other things, is that every now and then you'll find a parliament that will look at an area of law and completely revise the law, so a big section of common law is wiped out, the common law that was based on the old legislation.
Sorry, can you just define common law for a sec there?
Well, common law is a set of legal decisions that have set precedents and which bind following courts after them.
I thought common law and case law were different. I thought common law descended from the parts of the Westminster system that aren't directly legislated nor arise from the legal system. Like, I could be wrong, but I think common law is a specific thing separate to precedent.
Well, what I understand it is that they had a set of laws that were good but not always specific. And then when judges and magistrates had to make decisions, they would look for advice at decisions that had already been made. And eventually it became a binding requirement. Now, in Australia, I think the system is that a magistrates' court ruling is not binding on other magistrates' courts, but a district court ruling is binding on a magistrates' court. There's a hierarchy of relevance there.
Can I just quickly clarify that the court system in Australia goes, each state has multiple magistrates' courts and a district court.
Yep.
And it also has a Supreme Court. The Supreme Court, by definition, is the only state court that can hear appeals. Supreme Court also hears the most serious criminal offences, and oddly enough, they are also the only court that deals with will and probate issues. Then on the federal level, you've got the federal court, which deals with cases that are of national significance, but are not considered constitutional in nature, or a bit too run-of-the-mill to involve the High Court. And the High Court considers the most serious appeals, constitutional matters, and the most serious criminal cases, which for some reason can't be dealt with by a lower court. So that's the structure of the judiciary in Australia.
One thing I want to say about this particular presenter, if you look at some of her other videos, she is actually aligning with certain groups in the USA who are very pro-gun, and a lot of her position is about pushing that agenda and saying, hey, we should all be allowed to have guns, and we should all be allowed to defend ourselves, and we're the good guys and they're the bad guys, so we should be allowed to be the good guys and have the guns.
Yes.
That's not necessarily a pro-gun position. What it is an arch-libertarian position, where it holds the principle that someone's domain is sacrosanct, and that one should be able to defend that using any means necessary, whether it's your car or your house. Really what the arch-libertarians are arguing for is minimal government interference in what is considered one's personal domain. And of course the risk you run there is disproportional use of force is pretty much expected by the people who put forward those arguments, because what they're seeking to do is take the law into their own hands and mete out their own form of punishment / completely arbitrary or over-the-top self-defence against anyone that they see as having committed a crime.
Yeah.
Right.
So there's definite consequences to that point of view and to any movement in that direction. And if we look at society as a whole, I mean, I don't know about you, but I would like to say that I don't want to live in a society where I feel threatened by all of the so-called superheroes and great people out there who are, carrying around their guns and defending their lands from you wanting to put an envelope in their letterbox, or from you wanting to knock on their door to say, hey, your dog's out, or something like this, So a very benign act can turn into an overly violent situation in the presence of this kind of person.
I think most people would define themselves as good guys, no matter how bad they are.
Yep. Yeah, everybody feels justified to do what they do. That's pretty much the level of human behaviour there.
Yep.
Oh, some people more than others.
Absolutely, yeah.
There's some people who do stuff who then can't sleep at night as a result afterwards, and it doesn't. But on the other hand, there's people who can justify any particular thing they feel like doing or just happen to do on a whim.
And that's the point. You have some people that are very basically short-tempered. They just go berserk.
Yep.
I mean, there's not a lot of logic into it.
Yeah.
It's just they go berserk. Very nice. Listening to an interview with a famous detective from Melbourne who investigated lots and lots of murder cases, and he said, if you're investigating a murder, motive doesn't really help you very much. I mean, in the crime shows it does, but in reality it doesn't, because there might not be a motive. He had one case where the guy was playing his music a little bit too loud, so the neighbour thought, the neighbour just lost it, went down and killed him. No big motive there.
Yeah.
But it was definitely murder.
Yeah, understood. I'm noting the time. It is 9:15. I did just want to make one.
Some little boys need to go home to bed.
Yeah, absolutely. I did just want to make one final point on this, and that is about the use of pepper sprays and other sort of personal security devices, and how they are getting criminalised, I guess.
Stunts, yeah.
Yeah. And I see one of the reasons for that essentially is so that people don't go around having arguments with pepper spray. You know, so turning what is just a, you know, like your music's up too loud kind of deal into an attack of pepper spray or into a taser attack or something like that. So these are actual weapons as well, and by limiting their use, essentially we're putting a suppression on weapon use in general. So if people are going to settle debates, you know, it needs to be a debate. You know, at worst, a yelling match. You know.
Yeah, I mean the trend right now is to use a knife because everybody chops up their vegetables. But
I reckon you're more likely to get stabbed with a screwdriver than a knife in WA though.
perhaps.
Is that right?
Yeah. So perhaps we better stop assembling stuff with screws.
Yeah.
But at least having vegetable knives and screwdrivers is a whole lot safer than giving everybody a gun.
Yeah, absolutely. Yeah. So yeah, there's certainly merit in you know, restricting weaponry. There's certainly merit in the idea of restricting vigilantism, and certainly merit in the idea of having people settle their debates and their arguments with words rather than weapons. But that said, you know, if somebody breaks into your home, I do think there are extra considerations which could be written into law, which the police and judges can reference and use in order to protect those who are simply, very innocently, defending themselves in the presence of a flight kind of scenario.
And what would be some of your suggested alterations to the law?
One of them being a consideration of chronology.
Okay, let's look at chronology.
And I think the other one is it your home and is the other person a home invader?
Yes.
I mean, the fact that that's not in the law there is just a mistake.
Yes.
Well, in terms of chronology, that's a bit hard to nail down in the case where how provable is it that someone was breaking into your home for some reason? Is it different whether they would reasonably suspect that you were there or not at the time?
I would say it's a lot easier to prove that than it is to prove a measure of unreasonable reaction, unreasonable force.
But I would say the opposite. I'd say that being able to prove unreasonable force is pretty much based on what people have in terms of weapons, how physically strong they are, how old they are, whether any of them are infirm. All of these things I think are taken into consideration. But when someone breaks into a house, they could be a criminal, or they could be a confused drunk person who thinks it's their house, or they could be someone with a mental illness, maybe they're dissociated and they don't know what they're doing at the time.
These would be unfortunate circumstances, absolutely.
Yeah, but are they unfortunate enough to provide automatic protection from arrest from the person who was defending their home though?
It's a good question, but I don't think we've got the answers.
Well, hang on, I just want to jump in with the other half of my statement, which is, I don't think we need extra protections in the law to stop people being arrested.
Okay. Yeah, and you know, in the environment of Politify, you'd be able to put that statement forward, and it would be subject to those supporting it and those offering counter argument to it. In fact, everything that we've said would have that. Would have the opportunity to do that.
You were making a point, Ross?
I think we've got to move on, guys. Sorry.
Yeah, I'm going to go to bed.
So anyway, I don't think we'll go into any more videos, given the time of night that it is. I think we've had a good, rigorous, healthy debate, and I appreciate every contribution there. Yeah, so thank you for that.
Very good.
Yeah, and yeah, in terms of a project, I mean, depends on how passionate you are about this. You know, I like the idea of society having the ability to have a look at legislation and to have an influence on it. You know, an idea can come from a video blogger as much as it can come from a professional lawyer, as much as it can come from a politician whose job it is to review legislation and create new legislation. So why, I ask the question, why are we limiting it to only those two streams that we talked about? The legislative and the
Judicial.
Judicial arms.
If you're talking about changing the law, they're the people that do it.
At the moment, yes.
But
And
why do they change the law? You've got to look at
why are they the
intent
only ones
behind it.
debating it, is what I'm saying.
But
Why are
then-
they the only ones allowed to have any influence on that process?
They're not, and lots of people can have it.
Hmm.
The fact is that a lot of people, I think, feel a little bit locked out of the political system.
Yeah.
Political disengagement's a real issue.
It's not just disengagement, it's
I mean-
effectiveness.
You've
So-
basically got
I'm engaged, but I feel
two
ineffective.
major parties running the country. You don't really get much choice because it's going to be either one of them that's in government everywhere.
Not necessarily. We had a minority government in 2010. Well, that wasn't intended to be a joke. It was supposed to be a contradiction. Or a, yeah.
Yeah.
And-
Well, it was one of them in minority government,
Yeah.
wasn't it?
Well, here's
Yeah,
an idea.
but
When
it was
counter
substantially
arguments
different
are
too.
not always counter arguments.
Yeah.
When counter arguments are additional arguments.
Yeah.
That's something that we can
yeah.
take out.
And the membership of the major parties is shrinking.
Oh.
Oh yeah, they're desperate for members. They're not desperate for candidates to put up to Parliament,
Mm.
because there's always jostling for that. But their memberships are pretty bad.
How would we like to finish tonight, guys?
I don't know.
I'm going to finish tonight by driving home.
Right, so
You've done
Ross,
well.
you-
Thank you, Ross.
Yeah, yeah,
That's
yeah,
it.
yeah.
Fair enough.
Nice to
Yeah,
meet you.
yeah,
Yeah.
you too. Yeah, good on you for staying up.
Take care.